call today's hearing to order, or hearings rather, several. Four members are present. For the record, one will arrive a little tardy. She'll be tardy to the party. There are multiple cases on the docket. One was removed. That's Beverly Hills Unified School District case number 6263-1, which was a regular variance. It's off calendar. That's off calendar. We'll move very quickly to the next case that is before us, which is on consent calendar. County of San Bernardino Fleet Management case number 6070-13, regular variance rule 203. And the board will consider whether to grant a variance for more than 90 days. Members of the hearing board, you have within your possession, you have the minute order and other corresponding documents. We would like to mark subsequent exhibits. We're starting with number 6. Number 6 is the stipulation to place the matter on consent calendar. That's number 6. Number 7 is declaration by Lauren Doucette, Doucette. Then exhibit number 8 as proffered, findings and decisions of the hearing board dated December 4th, 2024. Any questions or comments relative to the exhibits? All right, is there any discussion?
Number 8 was the final decision?
Yes, sir. Number 8 is final decision. Number 7 is the Lauren Doucette declaration. And then number 6 is the stipulation to place the matter on consent calendar.
There was a proclamation of state of emergency that was included.
That's part of the stipulation. Any additional questions or comments relative to the exhibits? All right, any other questions on deliberation on this matter? Is there a motion?
I'm going to say, this matter, has come for us. I think they went through the series of ex parte and then interim, and then, they did ex parte, interim, and then they to the regular variance. So been granted really because they were violation of the rule. Of the permit condition because they've exceeded the 200 hours because of the fire and the control. And so they did, so what they're requesting is the ability to run the engines for an hour for testing until the end of the year. Starting today till the end of the year, as you all know, the hours will reset at the end of the year. So that's a request for a regular variance to run that engine for an hour for testing and maintenance testing. And we have waived the fees previously, so I don't think there's a need to waive the fee again, but previously it was under 303P because of the state emergency. So they made the exhibit 8, I think they did fairly, job in listing all the reasons why the violation was beyond the control, and they also had listed the excess emissions and so forth. So I don't see any problem granting the regular variance.
You can make a motion if you wish.
All right, in the matter of County of San Bernardino Fleet Management Facility item number 161266, case number 607013, I move that we grant a regular variance for the following rules and subsections as listed in Exhibit 6, as well as detailed in Exhibit 8, for the petitioner's equipment and permitting, et cetera, which is also listed in Exhibit 8. And as Mr. Balakapalan stated, we will waive the fees accordingly. The petitioner shall notify the clerk in writing when final compliance is achieved. Is there a second?
Second.
Second, Dr. Abraham. Any further question or discussion on the motion? Dr. Abraham, your vote?
Aye.
Mr. Balakapalan?
Aye.
Mr. Pearman?
Aye.
Ali in the affirmative. The matter is hereby approved unanimously. We're going to go off the record, sir.
The order has Cynthia attending, so maybe we should just strike that perhaps.
Yes, we're striking Ms. Verdugo Peralta and making certain that, just for the record, and make sure it's clear, that this matter was sunset on December 31st, 2024. All right, the matter is again approved unanimously with the exception of vote. We're going to quick recess, go off the record for about 5 minutes.
Contentious?
No.
There is still a microphone on. Can you guys mute, please? Thank you.
right, we're back on the record. Good morning. All right. Who do we have representing the executive officer?
Hi, good morning. This is Erica Chavez for the executive officer.
And Curtis Coleman for petitioner, Eastern Empire Utilities Agency, Inland Empire, excuse me.
Okay,
Utilities
and the
Agency.
case before us is the Inland Empire Utilities Agency for 5206-6. Just wanted to clarify, Madam Clerk, were there any individuals online to provide public comment, or whether it's public comment or whether it's evidentiary testimony? Okay, all right. And if they do, we'll just simply take them accordingly. All right. We have several exhibits that have been proffered this morning to the hearing board. And so the district has an exhibit. Your exhibit is the proposed interim variance condition. So this would be A, okay? And then
Yes, Mr. Chair, there are three exhibits that we would like to put forth, two photographs and a timeline. I don't know how, I know when we filed our petition, we marked the permits as exhibits 1 and 2. So I don't know if you want to continue with 3, 4, and 5 or
Yes.
mark. Okay, so
Madam Clerk, is that okay? As far as numerical sequencing? Okay, so for your purposes, would it just be easier just to allow these? Okay. all
okay,
right.
so these
we-
would be 1, 2, and 3.
Yes, so these sampling ports, pictorial flare number 1, flare number 2, flare number 3 would be exhibit 1. And then the sampling port dated November 12th, 2024 at 10:23 a.m. and 38 seconds, that would be exhibit number 2. And then the IEUA RPM 1 flare source testing timeline would be exhibit number 3. Are we okay with that?
Yes.
No problem, Madam Clerk. Okay. And so we're gonna move to opening statements. Well, before we do that, any witnesses on either side?
Yes, I have 2 witnesses.
I don't intend to call any witnesses, but I have staff from engineering and compliance, should you have questions.
Okay, so why don't we go ahead and just provide or administer the swearing in, as it were, of the oath.
Yeah.
If you're a witness, please stand. All right, place your right hand up. Or raise your right hand, rather. Do you solemnly state under penalty of perjury that the evidence you shall give in this matter should be the truth, the whole truth, and nothing but the truth?
Yes.
All right, all of you answer yes. They all concur, and we're moving forward. All right, Counselor, the floor
Yes.
is yours, sir.
Thank you. I'll move forward with the good cause portion of the hearing. I think, are we still doing the bifurcation?
Yes, bifurcated, yes. Good cause established, and then moving on to.
Thank you.
6 findings.
Inland Empire Utilities Agency is a public agency performing wastewater treatment services in the Inland Empire. It has several treatment plants, and the one at issue today is known as RP1. RP1 is located in Ontario, and the equipment at issue is there are basically 2 flares that are used to combust waste digester gas. Now, part of the wastewater treatment process involves the generation of gas that has methane and other organic compounds in it, as well as sulfur. And it needs to be combusted at a high temperature to comply with district regulations. Much of the gas is combusted for beneficial use in other equipment such as boilers, but in the event that the gas cannot all be combusted for beneficial use, there are flares that allow for the venting of the excess gas through the flares for combustion in the flares. The RP1 has recently been in the process of replacing an older flare with 3 brand new flares that meet district requirements under 1118.1, reflect best available control technology. 2 of those are currently operational. That's flare number 1 in the exhibit we'll get to in a minute, and flare number 3 shown in the exhibit. Flare number 2 is still in the process of being fully completed, and operation is imminent, but it has not yet begun. The flare number 1 and flare number 3 are identified in the petition by their permit numbers. The smaller flare in the picture is G61265. The larger one is permit number G61266. These flares were put into operation, and the permits contained a condition that required source testing to be conducted within 180 days after the flares were able to achieve a firing period of at least 60 minutes at the maximum flow rates achievable at that time. That occurred on May 29th of this year. These flares are being constructed pretty much as a turnkey operation by contractor WM Lyles Company. Lyles is responsible for constructing the flares and arranging for a source testing firm to be brought in, prepare the testing protocol, have it approved, and then do the source testing. The protocol was submitted, it was approved. When it came time to arrange for the source test, the earliest that the source testing firm could be on site originally was thought to be in late October, October 28th. That was when the notice was provided to the district that the source testing would begin. It had to slip a couple of weeks due to availability of personnel, so it didn't start until November 12th. Some testing was done on flare number 1 on November 12th. On November 13th, the next day, when they were attempting to do particulate testing, the testing company notified the Lyles representative on site that they could not complete it. They were concerned about the safety because the temperature of the flare, the proximity of their personnel to the flare and the temperature of the flare created safety issues in their view. The flare was operating normally, but they indicated they could not complete the testing on that date. The representative from Lyles, who we have here as a witness, will testify that they attempted to see if they could get perhaps a heat shield or a shroud fabricated in short order to shield the personnel from the heat. And it turned out that was going to take longer than they would need it to take in order to complete the source testing by the November 25th, 2024 deadline, which is when the 180-day period expired. They also looked for another source testing firm or firms that might be able to come in and do the test, and weren't able to find anyone who could do it before the end of the year. I was contacted, the testimony would be I was contacted immediately after the suspension of the tests on November 13th. And once the facility found out that the testing could not be completed by November 25th, we prepared the petition for an emergency and short variance and filed it on November 22nd, that Friday. And I will present witnesses to verify this, and we believe that that shows good cause for why a notice hearing could not have been held in time.
Ms. Chavez.
Yes, good morning again. Subject to the evidence presented this morning, the district does not anticipate opposing a finding of good cause to proceed. Thank you.
All right, members of the board, would you want to hear his witnesses? Are we comfortable with proceeding forward on the good cause?
I think we should move
Okay.
forward.
Okay, but he has witnesses. Are we comfortable with proceeding without his witnesses, or we want to hear his witnesses on the good cause?
I think we should hear.
Okay, fair enough. All right, Counselor.
Okay, thank you.
I just thought we might can expedite it, but there's no problem.
Okay, no, I will try to keep it brief, but full of facts. I'm going to call Pietro Cambiaso. Mr. Cambiaso, will you please state your name and spell your name for the record?
Pietro Cambiaso, C-A-M-B-I. Sure, yes, P-I-E-T-R-O. Cambiaso is C-A-M-B-I-A-S-O.
And were you sworn as a witness a few minutes ago?
Yes,
And you understand you're testifying under oath?
yes.
Okay. What's your association with the Inland Empire Utilities Agency?
I'm the manager of compliance and sustainability.
And how long have you held that position?
I have that position for 2 years.
Okay.
In sustainability.
Have you reviewed the petition for variances filed in this matter?
Yes,
And are the matters stated in that petition true and correct to the best of your knowledge?
yes.
And what type of equipment is involved in this variance request?
2 flares. They're used to combust waste-adjusted gas generated during the wastewater treatment process.
Okay. And is this equipment operated pursuant to AQMD permits to operate?
That is correct. According to the permit G61265 and G61266.
And are true and correct copies of those permits attached to the variance petition as exhibits 1 and 2 to the petition?
Yes,
Okay. Now, do you have photographs of the flares involved in this variance?
yes,
Okay. I'm going to show you the photograph that was previously marked as Exhibit 1. And does that show the 3 flares the 2 flares that have been constructed plus the one that's still being rendered operational?
that's correct. So the photo showed the 3 flares. Flare number 1 on the left side is the 12 million BTU per hour flare described in the permit G61265. You can see the sampling port on the top. Flare number 2 is the 27 million BTU per hour flare that is not yet operational. And flare number 3 is the other 27 million BTU per hour flare and needs to be source tested as well.
Okay. And can you describe what Exhibit 4 shows? Or excuse me, Exhibit 2.
Sure,
Exhibit 2.
yes. So this is the 12 million BTU per hour flare. They've been prepped for source testing by Alliance. You can see the Alliance personnel are using a man lift to get a person close to the sampling port.
Okay. Now, what rule or rules is Inland Empire Utility Agency violating at the current time?
Currently, we are in violation of the District Rule 203B and 3002C with regard to the requirement in the condition number 18 in the permits to operate the flares that require that a source test to be conducted on the flares within 180 days after each flare is able to achieve a firing period of at least 60 minutes at a maximum flow rate achievable at that time.
And was that milestone achieved on May 29th, 2024?
No, that was not achieved yet.
The
We were not able to source test it.
No, but did that meet the 60
Oh, yeah,
minute
that's correct, yes.
maximum flow rate?
Was achieved on May 29, 2024, and the source test to be completed by November 25, 2024.
Okay. Now, did Inland Empire Utilities Agency retain a contractor to construct the flare?
Yes,
And who was that contractor?
WM Lyles.
Okay. And has Lyles also done other work for you in the past?
That is correct.
And
Yes.
they've always performed satisfactorily?
Yes,
Okay. Was the contractor also responsible for arranging for the source testing required by permit condition number 18?
yes,
Okay, so in essence, did Inland Empire Utilities Agency rely on Lyles to retain a qualified source testing firm and have the source testing completed as required by the permits?
yes,
And to your knowledge, did Lyles retain a source testing firm to do the source testing?
yes, they retain Alliance Technical Group to perform the source testing.
And to your knowledge, is Alliance Technical Group a South Coast District approved testing lab?
Yes,
And did Alliance prepare a source testing protocol for the flare testing?
yes, a testing protocol was prepared. It was submitted to the district in October of 2022, and it received conditional approval on December 2nd, 2022.
Okay, now, when you got the conditional approval on December 2nd, 2022, were the flares ready to be tested at that time?
No, the flare did not meet the criteria specified in the condition number 18. However, we wanted to have an approved protocol in place so that the testing would not be delayed.
Okay. Now, did you provide advance notice of the testing to the district as required by condition number 18?
Yes, we notified the district on August 28th and conducted on week of October 28th. However, the data to be delayed to November 12 due to ability of Alliance personnel to do the testing. We also submitted a protocol for review on August 8th to make sure that it was still okay. And we received a second conditional approval on September 27th.
Okay, was November 12th the earliest date that Alliance was available to testing?
Yes,
And did source tests begin on November 12th?
yes,
Was it completed?
no,
Were you advised on November 13th that Alliance could not complete the sourcing as planned?
yes.
At that time.
We advised Alliance that we needed to complete source testing required by the permit. And we also contacted you regarding the situation.
Now, when did you first learn that the testing would not be able to be completed by November 25th, 2024?
On Monday, November 18th, we were advised by Mr. Van der Zee that Alliance could not complete the testing. They could not get another testing company in to complete the testing prior to November 25th.
Okay, and did you then prepare and file the petition for interim and short variance?
Yes, we were working with you to prepare the petition, which was filed on November 22nd.
And can you explain why the testing was not completed?
I would prefer Mr. Van der Zee to testify to that. He's the project manager for Lyles, and is more familiar with what happened on site on November 12 and 13.
Okay. That's all the testimony I have from Mr. Cambiaso, but I do have Mr. Van der Zee who will kind of pick up the ball and carry it from then. But any questions for Mr. Cambiaso? Welcome now.
Ms. Chavez on cross.
No questions for Mr. Cambiaso. Thank you.
Members of the hearing board.
Morning, Mr. Chair. Just a quick question, maybe the other person, right? There's a condition on your permit number 6 that requires a shroud. So the shroud that is referenced in the petition is a different shroud you're talking about?
That is correct.
It's more like a shield for the source tester versus a shroud on the flare?
That's correct. And maybe Mr. Van der Zee has more detail about the shroud that's been done. But yeah, that's correct.
Okay, that's all I had.
Sure.
Okay.
Mr. Freeman.
So it looks like you said that the earliest date Alliance could do the source test was November 12th, which is cutting pretty close to the November 25th deadline. So I read this timeline in Exhibit 3. I had protocols ready back in August 28th, approved September 27th. Why 60 to 90 days did it take to get the source test scheduled? Is it just Alliance's availability, or what was the reasons?
I think that would should be better directed to Mr. Van der Zee, the representative of Lyles who contracted with Alliance.
All right.
if that's, I don't know that Mr. Comby also has an answer to the question, so.
Yeah, I don't know I have the detail on that, but Mr. Van der Zee can address that.
All right, next witness, please.
Yes. Call Tyler Van der Zee. Mr. Van der Zee, please state your name and spell your name for the record.
My name is Tyler Van der Zee. First name's Tyler. Last name's Vanderzee.
And by whom are you, back up, were you previously sworn as a witness a few moments ago?
Yes,
You understand you're testifying under oath.
yes.
By whom are you employed?
WM Lyles Company,
And what is your job position with Lyles?
project manager.
And are you the project manager for IAUA's flare replacement project at the RP1 facility?
Yes,
Mr. Cambiaso previously testified that Lyles was responsible for retaining the source testing contract and arranging for the source testing to be completed. Is that also your understanding?
yes,
Did Lyles retain Alliance Technical Group to prepare a source testing protocol and conduct the source testing on the flares that are the subject of this variance petition?
yes.
Okay, I show you a document titled RP1 flare timeline, which is marked Exhibit 3. Have you reviewed this?
Yes,
Okay, is this an accurate timeline of events relating to the source testing of the two flares we have been discussing today?
yes, it is.
Okay. Board Member Perriman asked, why was there such a delay in between the time the protocol was approved in 2022 and the testing couldn't take place until November 12th? Can sort of explain what the gaps were and why they occurred?
The biggest gap was from the protocol being approved was approval of the programming for the flares. So we couldn't start it up until the programming was approved. And then once it got approved and we tested the flares, we were working through some bugs and some issues with the flares for a while that it wasn't until after the May 29th date that it was really operating fully without the existing flare.
So was this programming have to be approved by the manufacturer or the
IUA.
okay, got it, IUA. And what does the programming do? It just makes sure it operates as required by their needs?
Yeah, it tells the flares how to operate for IUA's needs.
Okay. So the flares were not in any position, were the flares in any position to be source tested prior to May 29th, 2024?
No.
Okay. So once you got the word that they were ready to be source tested, did you immediately try to schedule Alliance to do the testing?
Oh, after that May 29th date, we were still working through some issues with
Okay.
the start of the flare, so they weren't operating full-time and long enough to perform the test. So it wasn't until some time down the road that we got that final approval that the flares were good to run full-time. And then we contacted Alliance to see when they were available, and they weren't available till that November date.
Okay. Now, there was an original October 28th notification date. Was that, did Alliance come back and say, oh, we can't do it by the 28th, or we have to slip it, or what happened there?
Yeah, we had to give, I believe, 60-day notice for the test, and they initially said that they thought they would be able to make that date work, but then they came back and said that did not work for them.
Okay. So the testimony so far has been that the testing began on November 12th. Do you know if Alliance was able to obtain any data during the testing on the 12th?
Some partial data.
Okay.
Yes.
But they could not do all of the testing as required by the protocol?
No.
Okay. What happened that led up to the suspension of the testing?
So during the setup for the source testing, on the first day, Alliance ran through their pre-checks And at the time, they expressed concern with the temperature of the flare and the height of the stack, but still attempted the testing. After the initial tests, Alliance informed Dublin Lyles the temperature was too hot near the stack and they would be suspending the test due to concern for the safety of their employees.
Okay, now, I notice in the permit conditions that the permits list that are attached to the petition, there's a minimum flare temperature of 1,800 degrees. Is that correct?
Correct.
Minimum. Are these flares designed to operate at a higher temperature than that?
Yes, the set point's at 2,100.
Okay. So looking at Exhibit 2, the photo showing is that an accurate depiction of the Alliance, some Alliance person setting up for some testing to be done?
Yes.
And were they using a man lift to get them close enough to the port to use their sampling probes?
Yes.
Okay. When Alliance advised you that they could not complete the source testing, did you investigate any options that might allow for the testing to be completed prior to November 15th? Excuse me, November 25th.
Yes, we worked with the flare manufacturer to fabricate a shroud to provide additional shielding from the heat. We also contacted alternative source testing firms to see if they're available to test the flares within the allowable timeframe.
And what did you find as a result of that investigation?
First, there were no other source testing firms certified to do the testing required for the flares that had personnel available to perform the test before the end of 2024. Everyone who contacted had no availability. And then secondly, it was going to take weeks to fabricate the shroud extension. So there was no way we could get that in place and complete the testing by November 25th.
Now, when you talk about a shroud extension, have you gotten some information or plans or drawings back from the manufacturer indicating what they think a solution might be?
Yes.
Does that involve just extending the shroud up another 4 feet or so?
Yeah, extending the stack, yes.
Okay. Are you also still looking at alternative source testing companies?
Yes.
Okay. So anyway, by November 18th, that you concluded that it would not be possible to conduct the source test by November 25th?
Yes.
And did you at that point, advise Inland Empire Utilities Agency staff of that conclusion?
Yes.
Okay. That's all I have at this point on good cause.
Ms. Chavez on cross.
Yes, a few questions. Thank you. Okay, good morning. When did you initially contact Alliant to schedule the source test? Do you recall?
I do not recall the exact date.
Okay. Okay, but did you contact them as soon as it was ready to be source tested?
Yes.
Okay. And do you recall, so you have a date of May 29, 2024 when the flares were ready, but you stated that there was some time before the flares were ready to be source tested. Do you know how long that time was? An estimate?
It was the October. It is sometime in October. I don't have the exact date though.
No, sorry. I mean, when you determined they were ready to be source tested, so then you can reach out to Alliant to schedule the source test.
Can you say that one more time? Sorry.
Okay, sure. So you have a May 29th date, 2024. That's when you determined the flares were operational. But there, you just stated that there was some time before you were able to reach out to Alliant to schedule the source test because the flares were not ready to be source tested yet. Do you know how long that time frame was?
It was several months. I don't have an exact.
Several months, maybe around August 28th. That's when you contacted AQMD to notify AQMD of the source test date. Would it be around that same time?
Yeah, it would have been around there. Yeah.
Okay. Okay, and then I was wondering about, is there an explanation of why some testing was able to be completed on the flare and why it had to be stopped? Did the flare get hotter or, can you give a little explanation?
There's a difference between the tests they're doing. I think one, they were able to have the probe up there, not be up the whole time during the test. And then the other test, they had to kind of adjust the probe and be next to the stack for longer durations.
Okay, so it was during the, I think the PM test when the operator had to be closer to take the test when it became a safety concern.
Yes.
Okay, thank you. I don't have any other questions.
Members of the hearing board, Mr. Pierman.
Just so you couldn't say exactly when you first contacted Alliance through the source test, but can you approximate, say, related to the source test protocol reapproval of September 27th? Would it have been before that or after that? Any idea?
I know when we notified AQMD of the source testing, we had reached out for possible dates that they were available to come in.
So you have to notify 60 days in advance?
Yeah.
Okay, so presumably you asked Alliance sometime more than 60 days before November 25th at least, okay? And what other company at that time did you ask about source testability besides Alliance?
At that time, it was only Alliance because they were the only ones we were contracted with.
You have the company or allows an existing contractual relationship with them to use them?
But we set up our contracts with, we get the quotes and we work with whoever is the low bidder basically, and we contract with that company.
So you think you sought more than one source test company at the time and decided on Alliance, or did you just go to Alliance simply?
Can I get a clarification, Blair? What time period we're talking about? Are we talking about 2022 or are we talking about?
24.
Okay, so okay.
And is this at the time of notice of being notified, notifying AQMD?
Well, you notified AQMD that you're going to conduct a source test some 60 days after, correct?
Yeah.
In 2024. So at that time, presumably you had a source test company in mind.
Yes.
Was it just Alliance, or did you look to any other source test companies at that time?
At that time, no, just Alliance.
And the reason is
We had a contract. We had a contract with them, and they
that
provided.
started before September 24 with the company.
Correct.
And you mentioned IEUA programming approval needed. When was that approval obtained?
2022, the approval of the plan.
You said that you needed that approval to get the source test going. So if you met the plans, whatever you're referring to.
The protocol.
The program.
I think
The programming for the flares.
I don't have the exact date for that. It would have been before May
Of 2024.
of 2024.
All right, thank you. No further questions.
Mr. Balakapalan.
Yes, thank you. Morning, Mr. Vendisi. Just a question. So the exhibit 2 that we're looking at, and that's the flare number 1, right? They were trying to test. So they did, or was it the close-up of flare number 1?
Yeah, flare number 1.
Number
was the
1.
they were
So they
trying to
didn't try number 3, right? They did try it at 2 and 1, and it was too hot. Now, wasn't Alliance aware that they were testing a flare and that the temperatures, how come they were not prepared to do the test at that high temperature?
Temperature never came up in discussions with them. Apparently they are new to this type of flare. So they weren't expecting temperatures to be upwards of 2000. They were expecting more on the 1500 to 1600 range.
So this is flare 1, which is rated at 12 MMBTU, right? Flare number 3 is at 27 MMBTU, potentially could be much hotter too, right?
They're all set to the same
temperature. Okay. So just want to clarify when we talk about the shroud, can you explain a little bit what the shroud is? Because I was somewhat mixing with the shield. Maybe they needed a shield to shield them from the heat versus a shroud on the flare.
The shroud is an extension of the stack. The way they're set up in the lift, the sample port's only a couple feet from the top of the stack. So when they're in the lift, they're pretty close to that exposed heat from the stack. So the shroud is just an extension of that.
So they'll
So-
add more to the stack.
Yes, so that they're not as exposed to the direct heat from the flare.
Okay, so we heard that the manufacturer is designing that. Is that what, or they give specifications for the addition to the,
Yeah, they're providing details for
Details.
what we provide for that.
so what is the proposal to go with that manufacture of the shroud and attach it, or both? You're looking at another source testing company.
State that one
Oh,
more time.
let me see, the way it's worded, you're looking at two options. One is the shroud, adding the shroud, but sticking with the alliance, or you're still also adding the shroud, but maybe looking at another source testing company to do the tests.
Yeah, the preference is to provide the shroud and stick with Alliance because they have the approved
Okay.
protocol. If that becomes an issue, that's why we're still reaching out to.
And did you check with AQMD source testing group, what happens when you add the additional shroud, as far as whether it needs a reapproval of the source test protocol?
I did not.
Okay. All right. Okay, thank you. I have no further question.
Any additional comments? Ms. Verdugo-Prata?
Thank you. So I want to understand the time frame of this. When you originally became aware that there was a problem in regards to the flares being too hot for them to conduct the test, at that point, did you have any inclination to contact the AQMD at that point?
Yes, we did.
Okay, so in doing so, did you ask them for any suggestion and or a list of any other companies that perform this type of testing?
I did.
Well,
Okay.
we want to get back to there. Mr. Cambiaso can testify regarding what IEUA did. Mr. Vanderzee can testify to what he and WM Lyle's company did. So I think I'd prefer if the question is regarding availability of who was contacted about additional other source testing companies, that could be directed to Mr. Vanderzee. If it's I don't know who contacted AQMD for IEUA, but an IEUA representative should be testifying about what they asked the district.
Are they going to be available for questioning?
Who contacted? That you? Yeah. Okay. Yes.
Okay,
Well,
I'll wait till you
Okay.
bring her up.
So the challenge is, these are the only witnesses that he's calling, Ms. Verdugo-Peralta. He was not calling the young lady. What is your name, ma'am?
Sarah Rosento?
He wasn't calling Ms. Rosento. He was just calling. So if you want her to provide
I
testimony.
can wait.
Okay, well, no, the problem is, do you want her to be sworn in to provide? Because
Yes.
she didn't, did you take the oath? Okay, so we need to administer the oath, and then she can,
We can finish with these two if
very
you
well,
prefer, and
no
then
problem.
bring her up. So I'll wait.
Okay.
All right, we're down to closing, Mr. Coleman.
Well, I think we have one more witness.
Okay. Oh, so you want to bring,
I'll bring
so
Mr. Rosento
we're on
up.
good calls at this moment, Ms. Verdugo-Peralta. Do you want to hear her now or hear her subsequent? Okay,
Oh, okay.
right now. All right, Mr. Coleman.
Thank you. IEUA contracted with WM Lyle's company to construct flares and have them source tested and get the source testing firm in to do that. The flares hit a milestone that was specified in the permits, which was the firing for 60 minutes at the maximum flow of achievable at that time. That triggered a 180-day period, which meant that was on May 29th, 2024, which meant the source testing had to be done by November 25th. The testimony has been that despite hitting that milestone, there were still issues with the programming of the flare that rendered them not appropriate to have them source tested at that time, because the programming of the flares in terms of how they operated, started up, operated, switched over from whatever, the programming still had issues that needed to be worked out. Once those issues were worked out, we don't have an exact date, but apparently sometime in August, it was ready to be source tested, and notice was given to the district that source testing would be done beginning October 28th. Lyle's mobilized Alliance to come in and do the testing. Alliance indicated they could not do it the 28th. It was going to have to slip to November 12th. The week of November 12th, they came in, started the testing, and on the 13th determined that because of the temperature and the exposure of their worker to the temperature close to the flare, they could not complete the testing. Whether we filed a petition that week or the following week, there still would not have been enough time to have a notice hearing on a short variance. But the fact is, or the testimony has been, that it was not finally determined that the testing could not be completed by the 25th until the November 18th, at which time a variance petition was prepared and filed by the end of the week of the 18th. And we believe that that shows that the Inland Empire Utilities Agency did everything that it could to get to the hearing board and seek variance relief due to the inability of the source testing company to complete the source testing within the time period required by the permit.
Ms. Chavez.
Yes, thank you. The district believes that petitioner appears to have been diligent in attempting to get the source testing done by its deadline, and when it learned that it was not able to do so, kept the district apprised of its plans and also filed their petition to get to the hearing board quickly. So the district does not oppose finding of good cause to proceed.
Thank you. Deliberation. Members of the hearing board, Mr. Balakapalan.
Yeah, I do believe I can make the full finding necessary for good cause. They are in violation of a permit condition that requires them to do the source test within 180 days after achieving a firing rate at least 60 minutes with the maximum flow rate. That they are not able to do that, so they're in violation of the permit condition number 18 of both those permits. I'll skip the second one. I'll come back to that. And I think I do believe they are diligent. They were diligent once they knew they couldn't do it. They contacted Mr. Colburn and they filed for the variance. So they were quite diligent in petitioning for and scheduling the hearing for the interim. And the denial, and this is an essential public service, so the denial of the variance will, it will be unreasonable and unavoidable impact to the petitioner. I mean, they need the flare needs to be there to just in case of backup of the boilers and so forth. They're not utilizing all the digestive gas they're producing. But the second point, the circumstances leading to the violation could reasonably be avoided. I think that portion, and I fault the source testing company more than the petitioner per se. They should say that they didn't aware that the temperature was so high, and that they knew they were testing a flare. At the minimum, I would think they would have come out a day or a week before just to make sure, take preliminary measurements and know what they need for personnel and so forth, like the man lift and all that stuff. So I'm kind of surprised that, that was, they were unable to do the test because the temperature, flares will have elevated temperatures. So that's a given. So that sort of, the circumstances leading that, that I think the sources company should have been a little bit more diligent, let me put it that way, but nevertheless, I do find good cause to move forward to the next phase.
Any more questions, Mr. Pearman? Comments?
I'll support this a bit grudgingly because I see this a fair amount, and to my mind, as a business practice, once you know you've got this testing requirement of a certain date, it seemed to me you would get more than one company quickly on notice that I may need a source test in November and kind of at least be on their calendar, stand by, not wait till essentially the last minute when the 60-day notice period of the test comes up to pick someone. But apparently the industry standard is to wait. So I guess we have to go along with it.
Any additional comments on and our deliberation?
Yes, Mr. Chair.
Ms. Verdugo-Peralta?
Thank you. That is my issue. That a company that is responsible for providing service to the public doesn't have a plan B. And especially when it comes to something that you know that you have a deadline, and there's all kinds of possibilities with the flares. And in speaking with your original company that constructed them, I would think that you would have a list at the ready if one company is not able to do it, which is a little surprising that a company that's been in business that long would not be able to do it and wouldn't expect a problem such as this. They may never have seen it before. That's possible, but that's my problem. My problem is that there wasn't an urgency, especially being a public utility like this, that there wasn't an urgency to have another company to go to. However, because it is a public entity and because it is responsible to provide that service to the public, I will go ahead and support this.
Thank you very kindly. In the matter of facility ID number 009163, case number 5209-6, I move that we find good cause to proceed to a hearing for an interim variance and absence of notice to the public based on our discussion and ability to make the findings for good cause. Second by Dr. Abraham. Any further question or discussion on that motion? Hearing none. Dr. Abraham, your vote? Verdugo-Peralta? Mr. Bellica-Palan?
Aye.
Mr. Pearman?
Aye.
Ali votes in the affirmative. We're proceeding forward to the interim variance, and we will make certain that we bring forth all testimony as proffered in the establishment of good cause phase.
Okay, thank
Right.
you.
Now, just one quick question, Ms. Clerk. Just want to make sure no one is online. Okay. Very well. Mr. Coleman.
Thank you. I'm going to pick up with Mr. Vanderzee and then go back to Mr. Cambiaso for the closing. Well, I'll bring up Mr. Cinto as well. But right now, I'll finish up with Mr. Vanderzee. Mr. Vanderzee, what needs to be done now to, well, let me back up for a minute. Did you contact other source testing labs, firms, once you found out that Alliance could not complete the testing?
Yes,
Now, how many did you contact?
two.
Two. Can you name who you contacted?
Montrose Air Quality and Energy Environmental Solutions.
Okay. Is Montrose currently doing some testing work for Lyles at another project?
No, Energy Environmental.
Oh, Energy
Solutions.
Environmental is, okay. Did either of them indicate they might be able to do some work after the first of the year, but they could not do it before the end of the year?
Yes,
Okay, either of them or both?
both.
Okay, So is that still something you're looking into, is having one of those firms do the testing rather than Alliance?
Yes,
Okay. Now, the other alternative you're looking at is the shroud extension.
correct.
Okay. And can you describe what that involves? How much higher would the shroud be raised?
I just received a drawing yesterday and it shows at 4 feet.
4 feet. Now, with that, if the shroud was raised 4 feet, you expect to use the same sampling ports that have been approved by the district already for this testing?
Yes.
Okay. So do you have an estimate of how long it's going to take to fabricate this shroud extension?
A few weeks.
Okay. The conditions that the district has proposed, I believe, includes a requirement that weekly reports be provided to the district regarding alternative source testing contractors and the status of the shroud fabrication, extension fabrication. Is that your understanding?
Yes.
And is that any problem to provide those reports?
No.
Okay. Now, has a new date been scheduled for conducting the testing?
Yes, so we were scheduled for January 6th, 2025.
Okay, is that the earliest date possible?
Yes, given the fact that the work on the shroud extension will need to be done, and the holiday limits the number of working days available, that's the earliest we could schedule it.
And at this point, is Alliance still the firm that will be doing the testing?
As of now, yes.
Now, is it possible that the testing will not be completed by January 16th, the date of the short variance hearing?
Yes, it is possible. We're optimistic that we can get all the testing done during the first 2 weeks of January, but it's possible that we will encounter problems getting the shroud extension fabricated and installed, and that could result in delays past January 16th.
And is it also possible that even with the shroud extension, Alliance might balk at doing the testing?
Yes.
Okay. So is it your intention to fully pursue an alternative source testing firm?
Yes.
Okay. Let me ask another question. Are you aware of whether the district maintains a list of approved source testing firms for this type of testing?
No.
Okay. Okay, if I tell you, yes, the district has a list of approved firms with what they are authorized to do, is it, would you be willing to look at or contact those firms that are qualified to do this type of testing and see whether they are willing to do the testing using the existing protocol or whether they would have to submit their own protocol?
Yes.
Okay. And if they had to redo or submit a new protocol, would that likely delay the source testing even longer?
Yes.
Because it would need district approval.
Yes.
Okay. No further questions of Mr. Vandersee.
Ms. Chavez on cross.
Sure, thank you. Okay, is there a reason you've only contacted 2 firms so far for the source testing?
Montrose was given to us by IUA. They mentioned them that they've worked on flares like this before, so we contacted them, and then EES, like I said earlier, who were actually contracted with them on another project to test the same flares.
Okay, so you worked with them before?
Yeah.
Okay, and but I think you said both of them don't have availability before the end of the year, correct?
Correct.
Okay. And how long is the entire source test supposed to last if everything goes as planned?
For these two flares, 1 week, 5 days.
5 days, okay. And so is the plan currently to proceed with the previously approved protocol?
Yes,
Okay. But if changes are made, then you'll have to seek further approval from source testing.
yes,
Okay. And have you reviewed the proposed conditions provided by the district?
yes.
Okay, and is either, I guess, the facility and Lyle able to comply with those conditions?
I will ask Mr. Cambiaso that.
Okay,
Yes.
thank you. Okay, I don't have any other questions.
Members of the board? Mr. Balakapalan?
Yes, Mr. When does he, sorry, now the shroud, is that it, when you added, 4 feet extension, is that going to be a permanent fixture or is just temporary just for the testing?
Temporary for testing.
Okay. And then you've seen the proposed variance condition?
Yes,
Condition number 2 says, do you have that in front of you by chance?
I do not.
Okay. Anyway, that's okay. It says if requested by South Coast AQMD, petitioner shall submit a revised source test protocol. So do you know if somebody's in discussion with South Coast AQMD, if there's an extension added and whether there is going to have to be a need for revision to the protocol? Because it might affect maybe the cyclonic flow, in the stack.
Sorry.
So my question, I'm sorry, are you in communication with somebody in communication with South Coast AQMD source testing team about the potential addition of the shroud and whether that might need a revision to the source test protocol?
I am not, no.
We will.
All right, I've got no further question. Thank you.
Ms. Verdugo Peralta?
Thank you, Mr. Chair. Sir, you stated that you did contact 2 other labs for source testing. When was that?
This is the week of December 12th after we found out that the Alliance wasn't going to be able to complete the test.
And when again did Alliance tell you that they couldn't do it?
December 13th.
November?
Sorry, November.
So it was a month.
Right.
Is that what you're
Sorry,
telling me?
no, it wasn't December. The week of November 12th is when I contacted.
The other 2.
Yes, and it was after November 13th when Alliance informed us they wouldn't complete the test.
Okay, thank you.
All right. Okay, so why don't we did you want to finish or you want?
Finish with Mr. Cambiaso, and then we can call Mr. Cinto up. Okay. Okay, Mr. Cambiaso, getting back to addressing the findings the hearing board needs to make, have you considered curtailing operations in lieu of obtaining a variance?
We cannot curtail operations. The wastewater treatment facility operates 24 hours per day, 7 days a week. It continuously receives sewage from the surrounding communities, and we cannot control the amount of sewage we receive. The flares need to operate to dispose of the digester gas as required by our permit to operate the wastewater treatment facility. And even if curtailment or reduction in flow to the flare was possible, we will still be in violation of the permit condition requiring the source testing to have been completed by November 25th.
Do you expect any excess emissions during this variance?
No, we are not seeking any variance relief from any of the emission-related conditions.
And the conditions require Inland Empire Utilities Agency to submit quite a bit of data regarding the flare operation and the gas inflows and things like that. Is it your belief that that will allow the district, and also a preliminary whatever information that the source testing company was able to obtain prior to suspending the source test. Do you believe that will assist the district in determining whether there are any excess emissions during the variance?
Yes.
Okay. What would be the effect on Inland Empire Utility Agency's customers and the public if this variance is not granted?
IUA would be exposed to civil penalties for violation of District Rule 203 and 3002. If the flares are not operated, IUA will still be in violation of those rules as a condition in the wastewater treatment facility permit that require the adjusted gas to be vented to the flares. And those penalties would have to be paid by our customer in our service area.
Can you quantify the emissions during the variance period?
As you mentioned, the permit requires us to continuously monitor the adjusted gas flow to each flare and test for BTU content of the adjusted gas weekly. This will enable us to quantify emission, and this information will be available to the district.
And for what period of time are you requesting a variance?
We currently have a source testing schedule for the week of January 6, 2025. So we would like a variance granted beginning today and lasting until the short variance hearing. If we complete that testing before the short variance hearing, we will advise the hearing board that we are in the compliance. And if any problem arises, we will need more time, but we can address that at the variance hearing scheduled for January 16, 2025.
And have you reviewed the proposed variance conditions submitted by the district as their Exhibit A?
Yes.
And are they acceptable?
Yes.
Okay. All right. Nothing further from Mr. Cambiaso.
Chavez.
Thanks. Just one question. One of the conditions, number 4, asked if it's possible to prioritize or divert the digester gas. Is that a possibility to lower the extent of use of the flares?
We are maximizing the use of the biogas to the boiler. So yes, that's our goal ultimately.
Okay, to the boilers you said.
Yes.
Okay, thank you. No further questions.
Thank you. So why don't we go ahead and administer the oath?
I'm sorry, I had a follow-up question.
Okay, go right ahead, Mr. Malakapalan.
Actually, Mr. Chavez brought up condition number 4. I was looking at that. Did you remove the old flares or they still, do you have other flares on site or they've all been removed?
We removed the old one. Right now, there's the 3 flares, 1, 2, 3, only 1 and 3 are operational. Number 2 is not.
So the
Yeah.
condition saying maximize use of other boilers which you have, but that just gas-fired flares you really don't have unless you bring a rental, right?
That is correct.
Okay, so it's better to put that in and not take it out. Just as you're not planning to bring a rental in, correct?
No, we plan to conduct the test as soon as possible.
Okay, all right. So just okay, maybe I'll suggest removing that flare. Would that be an issue if that just a gas-fired flare? Because you don't have any
We
other
don't have any other ones you can.
No, we don't. Yeah, we can remove it.
except for those
Strike
2.
that out.
Okay, all right. I have no questions. Thank you.
Thank you. So we're going to dismiss these witnesses or do we want to keep them? And we're going to administer the oath. Okay.
Well, may I just say
Go
that
right ahead, Ms. Paducah.
quite honestly, the answers that I've been receiving from the existing witnesses right now, I don't think we need to pull
No
that
problem.
third party up.
No problem. Okay. Just a quick break from protocol. Ms. Chavez, did you confer with your team relative to the comments Mr. Balakapalan made?
I did, yes.
Are you comfortable with striking that language?
Yes, that would be okay.
Okay, and
Yes,
Mr. Coleman?
we agree.
Okay, why don't we move to closing?
I'll be very brief, as I think I've flogged the horse. The testimony has been since the good cause established that they're in violation and that it's due to conditions beyond their reasonable control. We also do not believe there are any excess emissions. Curtailing operations would not, or limiting operations would not result in compliance. So that's not an option of not obtain, of an option to obtaining a variance. We don't believe they're excess emissions, and the operation of the flares in terms of the heat input, the gas, the heat value of the gas, the amount of gas flared, the temperature of the flare during the operation. A lot of this information about the flare operation will be submitted to the district on a weekly basis that will allow them to determine what the emissions are and if there are any violations of permit conditions or excess emissions. So we believe all the findings can be made to support the granting of an interim variance. And we would like the variance to extend from today to the date of the short variance hearing. And if the testing gets done before then, we will notify the hearing board and council that the facility is in compliance. If not, we'll be back here in January and explain what we are going to do to get back into compliance.
Mr. Alvarez?
Thank you. Yes, the district is agreeable that the 6 findings can be made and does not oppose the granting of the variance subject to the district's proposed conditions, which have been agreed to by the facility. Thank you.
And those are in Exhibit A. Exhibit A. All right, on Mr. Balakapalan?
Yeah, I do agree. I can make the 6 finding. The petition is in violation of condition number 18 of the 2 permits that were referenced in the petition. Non-compliance is beyond the reasonable control because they did schedule the source test, but unfortunately the source testing company could not complete it. And the closing of taking would be thought it was corresponding to reducing character. The petition always benefit the quality because we don't expect any excess emission. So condition finding 5 and 6 relates to excess emission, and there's during this period. And however, they are required to provide some information of the flows and so forth as part of the condition. So I do believe I can make the 6 finding, and I can be happy to make the motion to when we finish deliberation.
All right, any additional? Mr. Balakapalan, the motion is yours.
I think Ms.
I'm sorry, Mr. Duprat.
Thank you. I can make the 6 findings. I would just strongly suggest that as you're going forward, that you do have a fallback plan B, and another company notified that if this one company cannot successfully complete the source testing, that you will have somebody in the wings waiting, just in case. Thank you.
All right, seeing no other members seeking recognition, Mr. Balakapalan.
Okay. In the matter of Inland Empire Utilities Agency, case number 5209-6, I move that we grant an interim variance commencing today, December 4th, 2024, and continuing, ending in 90 days or until a notice hearing for interim variance currently scheduled for January 16, 2025, whichever occurs first, from rules 203B and 3002C1, and specifically condition 18 of the 2 flares, permit number G61265 and G61266 for the equipment located at 2662 East Walnut Street in Ontario, California 91761. The variance condition as set forth in Exhibit A with that strikeout of condition number 4 of the digested gas-fired flares on that condition in Exhibit A, and there are no anticipated excess emission during this period. And that actually concludes my motion.
In your motion, just to be clear, we're going to incorporate Mr. Coleman's request.
Which request?
His request was the extension until the hearing. And
well, yeah, that's already, it's until the, whichever is 90 days or until the schedule interim, short variance.
Just wanted a little clarity. Is there a second on the motion?
Second.
Okay, moved by Mr. Balakapalan, second by Dr. Abraham. Any further question or discussion on that motion?
What's it?
No existing emissions?
No excess.
No excess emissions, no.
And you, Madam Clerk, I'm sorry, did you get added to condition number 4? No, just that one, where it says digested gas fired flares, only that strike out on that, not eliminating the whole condition. Fired flares, yeah.
All right, on a roll call, Dr. Abraham.
Aye.
Ms. Fiduco Peralta,
Aye.
Mr. Balakapalan.
Aye.
Mr. Perman.
Aye.
And Ali votes in the affirmative. The matter is hereby approved unanimously. Mr. Coleman, you have some final comments? I see you gearing up.
Thank you. Thank you, members of the board. Pleasure to be before you again.
Nice to see you again.
All right, at this moment in time, if there's no additional business before the body, we will adjourn at 10:53 a.m. We're off the record.
Okay, Cynthia, how you feeling?
Too bad. I don't know what I
Oh, I'm sorry.
hurt my shoulder when it stopped all of a sudden.
Yeah.